Good afternoon. I'd like to welcome you to this year's annual Sumner Canary lecture. This lectureship, which was established to honor the memory of the late Judge Sumner Canary, is perhaps the law school's premier endowed lectureship, and I can think of no more fitting person to deliver this year's lecture than Professor Randy Barnett, who I will introduce in a minute. As I mentioned, this lecture was created to honor the memory of the late Judge Sumner Canary, who was not only a judge on the Ohio Court of Appeals for the 8th District, but also a U.S. Attorney for the Northern District of Ohio and a prominent practitioner in the Cleveland community. And we are certainly grateful to Judge Canary's widow, Nancy Canary, who helped make this lectureship possible. Today's lecture is going to be given by Randy Barnett, who is the Carmack Waterhouse Professor of Legal Theory at Georgetown University's Law Center, where he teaches constitutional law and contracts. He's a graduate of Northwestern and Harvard Law School, and his legal career spans a stint in the Cook County Prosecutor's Office and teaching at Chicago, Kent, at Boston University, visiting at Northwestern, Harvard, and the University of Pennsylvania, a 2008 Guggenheim Fellowship, writings that range from works on constitutional law and contracts, multiple case books, edited volumes, and even a work of political philosophy. But unlike some academics, still continues to keep an active or in the practice of law, litigating cases like Gonzalez versus Raich, a Commerce Clause challenge to the federal prohibition on the possession of marijuana for medical purposes under state law, all the way up to the Supreme Court, and was also one of the attorneys for the National Federation of Independent Business in the healthcare case NFIB versus Sibelius that the Supreme Court decided last year. And most interesting, and perhaps, at least to me, among his many media appearances include being a guest on the Ricky Lake Show, and a speaking role in a small independent film called Inalienable, which was written by Walter Koenig, who some of you may remember as Chekhov from Star Trek. But enough from me. I'm not why you came to hear or came today. I'm going to turn it over to Professor Barnett, who is going to give a lecture on the legacy of Chief Justice Salmon Chase, a legacy which I think he argues quite persuasively is something that we would do well to remember better. So without any further ado, Randy, it's all yours.
Well, thank you, Jonathan. It's great to be here, and thank you all for coming. I actually have quite a lot to say about Salmon Chase in this lecture, so I'm just going to get into it and dispense with many of the preliminaries, so I'm not going to keep you over. For several years, I've been studying a long-forgotten band of constitutionalists who, in the 1830s, 40s, and 50s, denied that the U.S. Constitution was pro-slavery. They advocated enforcing the text of the Constitution without any gloss put upon it by intentions, understandings, or deals that were not expressly included in the text. They contended that Congress not only had the power to ban the international slave trade, it also had the power to ban the interstate slave trade and to abolish slavery in the District of Columbia, in the territories under its jurisdiction, and in any states that were formed from these territories. They also contended that the Fugitive Slave Acts of 1793 and 1850 were unconstitutional. These positions put them at odds with other abolitionists, the Garrisonian abolitionists, who claimed that the Constitution was a covenant with death and an agreement with hell because it sanctioned slavery. The constitutional approach of this group deserves its own label, and a label that I have given it, which was a label they used themselves, was constitutional abolitionists. Like the radical abolitionists, constitutional abolitionists declared desired the complete abolition of slavery. Unlike some Garrisonian abolitionists, however, the constitutional abolitionists believed that the Constitution was fundamentally anti-slavery. Constitutional abolitionists were, however, divided amongst themselves on one key issue. Some contended that slavery was unconstitutional anywhere in the United States. Others believed that while slavery should be abolished everywhere, as a matter of positive law, slavery was constitutional within those of the original 13 states that had retained that practice. Now, I describe in the, I guess you got a handout for CLE or other purposes in which includes an article of mine that was published in the Journal of Legal Analysis a year ago, which is a sustained treatment of all of these constitutional abolitionists, and that's what's there. There's going to be a new article based on, that this lecture is drawn from, on Salmon Chase himself, that'll come out in the Case Western Law Review. The leading figure in the second camp of abolitionists, the ones that thought that the Constitution was anti-slavery but still allowed slavery in the original 13 states, that still retained it, the leading figure in this second camp was Salmon P Chase. Of all the figures I surveyed in my article, none were more important than he. Whether you know it or not, you have all heard Chase's name, and many of you have used it, and most of you see it every day. Yes, that's right. The Chase Bank, originally founded in 1877, some 4 years after his death, was named in his honor. As one drives down the streets of most cities, one sees Chase's name prominently displayed, illuminated in the darkness. But even if you do not know his name, or even if you do know his name, if you're like me, you may not remember exactly who he was and what he did to earn this posthumous honor. Now, perhaps you know that he was Chief Justice of the United States. Perhaps you even know that he was a politically ambitious rival of Abraham Lincoln, who himself wanted to be president. But what he stood for throughout his accomplished career has largely been forgotten. For long before he was Chief Justice of the United States, Salmon P. Chase was among the most prominent, brilliant, and ultimately politically effective members of this group of constitutional abolitionists that I described. By forgetting them, we have forgotten him. Salmon Portland Chase was born in New Hampshire in 1808, the year that Congress abolished the slave trade. He was 9 when his father died, and by the time he was 12, his mother found himself unable to support him and his siblings. She prevailed upon her brother-in-law and Chase's uncle, Philander Chase, to take him into his care. Philander had just become the Protestant Episcopal Bishop of Ohio and was running a boys' school in Worthington, Ohio, just north of Columbus. His trip to the Western Reserve was an adventure for the young boy. His 23-year-old brother and neighbor, who were both joining an expedition to Michigan and Wisconsin, would take him by steamship as far as Cleveland. According to one of his biographers, in 1820, Cleveland, quote, was not much to see. A hamlet with a population of about 500 people, dwellings straggled across a heavily wooded bluffs that rose sharply from the lake, unquote. As there was no harbor then, small boats conveyed the party to the mouth of the Cuyahoga River. In Cleveland, Chase was boarded with a local judge named Barber until someone could be found to take the boy to Worthington. Eventually, an Episcopal minister took him as far as Medina, where 2 other clergymen got him to his uncle's place. Just picture that, this 9-year-old kid coming from New Hampshire with his brothers and then basically left in Cleveland before someone could take him down to where his uncle is. Chase lived with his uncle there in Worthington for 2 years until no longer able to make a go of his school. Philander accepted the presidency of Cincinnati College, which brought Salmon to the city where his legal and political career would begin. But first, Chase went back east for college at Dartmouth, very near his boyhood home. After graduating in 1826, he moved to Washington, D.C., where he first tried his hand as a school teacher, before deciding to study law with Attorney General William Wirt. Studying in Washington gave Chase the opportunity to watch cases argued before the Supreme Court. Being associated with Wirt and his family enabled him to meet many of the most prominent political and legal figures of the day. When, after just 2 years of study, Chase applied for the bar, his examination by the judges went well, until he was asked about the length of his legal training. When he admitted that it was not the required 3 years of study, the presiding judge instructed him that he would need to study another year. Chase pleaded with the court, quote, "Please, Your Honors, I have made arrangements to go to the Western country and practice law there." After a brief conference, the judges decided to swear him in as a member of the bar. One can imagine that as long as he was going out west to practice law, they didn't care so much. Chase's law license secured, in 1830, he returned to Ohio, where he practiced law in Cincinnati. In those days, Cincinnati was a political cauldron. Its proximity to the slave state of Kentucky enmeshed it in the slavery economy, and much of its citizenry was sympathetic. But Cincinnati's location also made it a refuge for anti-slavery Southerners who no longer felt welcome in their home states. One such refugee was James Birney, a former Kentucky slave owner and Princeton-educated lawyer who turned against slavery and left his state for Cincinnati. There, Birney founded an abolitionist newspaper called The Philanthropist. In 1836, Chase was drawn into anti-slavery activities when a mob attacked Birney's newspaper, destroying the press. At the time, Chase had yet to take any public stance on the slavery question. But when he heard that a mob was heading to Franklin House to tar and feather Birney, Chase raced to the hotel to warn the publisher. In her book, Team of Rivals, Doris Kearns Goodwin describes the scene. As the mob surged forward, Chase braced his arms against the doorframe, blocking the hotel's entrance with his body. 6'2", with broad shoulders, a massive chest, and a determined set to his jaw, Chase gave the rioters pause. The crowd demanded to know who he was. Salmon P. Chase, the young lawyer replied. You will pay for your actions, a frustrated member of the mob told him. I can be found at any time, Chase replied. In fact, it was members of the mob who were made to pay damages when Birney retained Chase to bring a successful tort action against them for the property damage they'd caused to the press and the office. In 1837, Birney again enlisted the 29-year-old Chase, this time to represent a young runaway slave named Matilda, who had been seized by slave catchers. Matilda was the light-skinned daughter of her owner, who had brought her with him on a long trip through the free territory in the North, passing as his white daughter. Having tasted freedom, she pleaded with her father for a certificate of emancipation, but he refused. She then fled to a small neighborhood of free blacks in Cincinnati, where she found refuge before coming into Birney's employ as a maid. Chase brought a writ of habeas corpus for her freedom and argued the case before a local judge. Chase's hastily prepared argument was multifaceted. The Fugitive Slave Act of 1793 authorized a slave owner to seize a fugitive slave in a free state and return her to bondage after obtaining a certificate of removal from a federal judge or a state magistrate in the free state. One of Chase's principal claims was that the Fugitive Slave Act was unconstitutional because it was beyond the delegated powers of Congress to enact. The Fugitive Slave Clause of Article 4 says that no person held to service or labor in one state, under the laws thereof, escaping into another, shall, in consequence of any law or regulation thereof, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. That's Article 4 of the Constitution. According to Chase, unlike the provisions of the first three articles, Articles 1, 2, and 3 of the Constitution, which create, define, and empower the national government, Article 4 contains clauses of compact between the states themselves. Such, quote, and this, now I'm quoting from his argument, such clauses of compact confer no powers on the federal government, and the powers of that government cannot be exerted except in virtue of express provisions to enforce matters of compact, unquote. To further support his compact theory of Article 4, Chase contrasted Article 4's Fugitive Slave Clause with the Full Faith and Credit Clause that's also in Article 4. After imposing a duty on each state to give, quote, full faith and credit to the public acts, records, and judicial proceedings of every other state, unquote, Article 4 there, and only there, gives Congress a power to, quote, prescribe by general laws the manner in which such acts, records, and proceedings shall be proved and the effects thereof, unquote. Chase then posed the following challenge to the court. Quote, am I not right in saying that the framers of the Constitution were aware that without this special provision, Congress would have no power to legislate on the subject of this section? Unquote. If the first clause by its own force, quote, confers on Congress legislative powers, he asked, why add the second? Why add it if legislative power is conferred by the general grant or by any other provision in the Constitution, unquote. Nor could the necessary and proper clause be used to support the Fugitive Slave Act, according to Chase. Quote, the general grant of legislative power is expressly confined to the enactment of laws necessary and proper for carrying into execution only those enumerated powers that are vested in Congress. He then quoted the words of the 10th Amendment as authority for this claim that the power to enforce the duty to return runaway slaves is reserved to the states and was not granted to Congress. Chase's argument failed to convince the local judge, who remanded Matilda to the slave catchers. She was swiftly taken down the river to be sold at auction in New Orleans. Her fate then lost to history. But Chase's argument in her defense was published as a pamphlet and distributed widely throughout the country, where it elevated his visibility and provided the legal basis for other challenges to the constitutionality of the Fugitive Slave Act. Chase's legal defense of Matilda and other fugitives earned him the nickname of, quote, the Attorney General for Runaway Negroes from his critics in Kentucky, a title he then appropriated as a badge of honor. His enumerated powers argument, like so many of the abolitionist constitutional claims, seems powerful and almost obvious when first encountered. Yet these arguments and the men who developed them are largely unknown today. They are rarely mentioned in law school, and that's true even when the topic of slavery in the Constitution arises. Years later, in 1846, Chase would present a more developed version of this argument to the Supreme Court of the United States in the case of Jones v. Van Zandt. In his Van Zandt brief, Chase renewed his structural objections to the Fugitive Slave Act as outside the enumerated powers of Congress. But to this he then added a due process clause objection of the sort that had become popular among constitutional abolitionists. Quoting from his brief now, quote, now unless it can be shown that no process at all is the same as due process of law, Chase contended, it must be admitted that the act which authorizes seizures without process is repugnant to a constitution which expressly forbids it. Slaves, unquote, slaves were entitled to the protection of the clause, he argued, because they were persons, which is an interesting claim. Here's what he says, quote, it is vain to say that the fugitive is not a person, for the claim to him can only be maintained on the ground that he is a person, unquote. And why is that? Because, as the abolitionists like to point out, he referred to the wording of Article 4, the Fugitive Slave Clause of Article 4, which says, no person held to service or labor in one state. Well, if no person held to service or labor in one state is a reference to slaves, which that's the assumption that it is the Fugitive Slave Clause, after all, then the later enacted, 2 years later enacted Due Process Clause, which also refers to persons, would have referred to the very same people that are covered in the Fugitive Slave Clause. And therefore, the Due Process Clause would cover them as well. Chase's Due Process Clause challenge rests on the summary manner by which slaves were to be recaptured under the Act. Suppose an owner of a horse, he said, should find the animal in the possession of his neighbor, and instead of resorting to due process of law and the old-fashioned replevin, simply seize the animal and take him before his own hired magistrate and prove his claim by affidavits. Or, if he claims a failure to provide services, quote, instead of suing him for breach of contract, let him drag his reluctant neighbor before a magistrate, establish his claim, and then remove him to his task. Chase asked, how long could society hold together if this principle were carried into general application? Near the end of his brief, Chase identified, quote, certain great principles of natural right and justice, unquote, which he said were intended to establish as written law in the Constitution, but which exist independently of all such sanction. As examples of these, he said, are the following. No legislature is omnipotent. No legislature can make right wrong or wrong right. No legislature can make light darkness or darkness light. No legislature can make men things or things men. Nor is any legislature at liberty to disregard the fundamental principles of rectitude or justice. Whether restrained or not by constitutional provision, there are acts beyond any legitimate or binding legislative authority. Chase then allowed, of course, that he said, quote, it must be a clear case which will warrant a court in pronouncing a law so unjust that it ought not to be enforced, but in a clear case, the path of duty is plain, unquote. Notice here another forgotten fact. Before the Civil War, it was the slave power who enlisted the power of the federal government to impose the Fugitive Slave Acts. It was the northern states who complained about the interference with their rights to protect their free blacks from being kidnapped by slave catchers and sold down the river. States' rights was as much an anti-slavery as a pro-slavery doctrine. Chase's brief in Van Zandt was published as a pamphlet and received wide circulation. The case added considerable luster to Chase's national reputation as both a principled opponent of slavery and a defender of the Constitution. But it came 4 years after the court had rejected similar arguments in the case of Prigg versus Pennsylvania. In Prigg, Justice Story upheld the constitutionality of the Fugitive Slave Act by adopting an expansive interpretation of the necessary and proper clause. Chase's argument in the Matilda case in the 1830s shows that Story's capacious reading of the necessary and proper clause was far from inevitable. Story's analysis only seems compelling when the arguments on the other side are omitted. We are accustomed to hearing that a sweeping interpretation of the necessary and proper clause is needed to ensure, for example, the constitutionality of civil rights laws. Yet Story's use of the necessary and proper clause in Prigg shows that a broad reading of congressional power can also be used to uphold evil. Now let me now turn my attention from Chase's anti-slavery activities as a lawyer to his anti-slavery political activity. Unlike the Garrisonian abolitionists, who disapproved of political action, Chase engaged in electoral politics to pursue his anti-slavery agenda. In the 1840s, Chase helped form the Liberty Party and became one of its leaders. But even as he was working to build the Liberty Party and then the Free Soil parties, which I'll mention in a moment, Chase came to view himself as a Democrat. Like others, he sometimes called himself an independent Democrat or a free Democrat to designate the anti-slavery position, a movement he hoped would one day capture the heart of that party. Part of his motivation was practical, as Cincinnati was strongly Democratic. But principle also played a major role. Chase was of the belief, confirmed after years of study, that Jeffersonian idealism was basically more appropriate to the abolitionist objective than the Whig program of economic development through national planning, which a strong national, central government would then devise and execute. He said, "I do not concur in Whig views of public policy, either as an anti-slavery man or as simply a citizen." That Chase came from a Democratic Party background and from Southern Ohio will explain much about his political sympathies. His strict construction, actually, I just misspoke. The Southern Ohio part figures in a second, not in this part. So let me restate this because I don't want to mislead you. That Chase came from a Democratic background will explain much about his political sympathies. His strict constructionist views of the Constitution, his belief in laissez-faire, opposition to economic tariffs, and his support of hard money over paper. It also explains the antipathy that later developed towards him by the Whigs who dominated Northern Ohio, and later by the former Whigs who joined the new Republican Party, as well as the tension that later developed between former Democrat Chase and ex-Whig Abraham Lincoln. In 1845, Chase addressed the Southern and Western Convention of the newly formed Liberty Party on the question of the constitutionality of slavery in Cincinnati. This is where the event was held. No less than 100,000 copies of his speech were printed and circulated in pamphlet form. In his speech, Chase declined to adopt the view that had been expressed by other abolitionists, including members of the Liberty Party, that no slaveholding in any state of the Union is compatible with a true and just construction of the Constitution. In other words, he conceded that within any of the states that were part of the original 13, the retention of slavery was constitutional. But he favored instead its removal from each and every state by state authority. On the other hand, Chase contended Congress had the power to outlaw slavery in the District of Columbia and in the territories. Now, once again, given that Congress has a police power in these places, akin to the police power of states within their own territories, it would seem like an obvious proposition that Congress would have the power to abolish slavery in the District of Columbia and in the territories over which it wields something like a police power. Yet at the time, it was vehemently denied by pro-slavery Democrats in Congress who claimed that abolishing slavery would deny the slaveholders their property rights in violation of the Due Process Clause of the Fifth Amendment. In fact, there was a congressional committee that issued a report in the 1830s that said exactly that. 20 years later in Dred Scott, Chief Justice Taney would extend the same due process protection or Due Process Clause reasoning to the territories. In his 1845 Cincinnati address, Chase proposed the following anti-slavery political program, and these are 5 planks that I'm quoting from him. Repealing all legislation and discontinuing all action in favor of slavery at home or abroad, prohibiting the practice of slaveholding in all places of exclusive national jurisdiction in the District of Columbia, in American vessels upon the seas, in forts, arsenals, navy yards, forbidding the employment of slaves upon any public work, adopting resolutions in Congress declaring that slaveholding in all states created out of national territories is unconstitutional and recommending to the others the immediate adoption of measures for its extinction from their respective limits. And finally, 5, electing and appointing to public office only those who openly avow our principles and will honestly carry out our measures. Chase maintained that, quote, the constitutionality of this line of action cannot be successfully impeached. Chase's political program was enormously influential. Historian Harold Hyman described Chase as, quote, the anti-slavery crusaders' premier legal strategist. Historian Eric Foner has observed that in these and other strenuous efforts, Chase developed, quote, Chase developed an interpretation of American history which convinced thousands of Northerners that anti-slavery was the intended policy of the founders of the nation and was fully compatible with the Constitution. Within a few years, it provided the core position of a new anti-slavery party that would supplant the Whigs and capture the presidency and Congress. Quote, Chase's interpretation of the Constitution, wrote Eric Foner, formed the legal basis for the political program which was created by the Liberty Party and inherited in a large part by the Free Soilers and Republicans. Again, quoting Foner, because of Chase's efforts, this anti-slavery of interpretation of the Constitution eventually came to form the constitutional basis of the Republican Party program. That the Republican Party's national program, platforms, for the election of 1856 and 1860 largely adopted Chase's constitutional views on slavery helps explain why Lincoln's victory in 1860 provoked the Southern states to secede. There's always a bit of a mystery since Lincoln kept saying over and over again he wasn't going to interfere with slavery in the South. So why did they secede? Although, like Chase, Lincoln insisted that he wouldn't interfere with slavery where it existed, Southerners apparently feared that the Republican program would hasten the extinction of slavery throughout the United States, which was, after all, its intended purpose. From 1849 to 1855, Chase served as United States Senator from Ohio, as a member of the Free Soil Party. Indeed, Chase coined the motto of the Free Soil Party, which was free soil, free speech, free labor, and free men. The manner by which he attained his position as senator would haunt him politically for the rest of his career. When the Free Soilers successfully obtained the balance of power in the 1848 election for the state legislature, Chase struck a deal with the Democrats, whereby they would agree to abolish the black codes, which were in existence to impose a discrimination against free blacks in Ohio, and they would vote to name Chase U.S. Senator. The Democrats agreed to both conditions, and they fulfilled both conditions. In other words, they abolished the black codes as they had promised, and they named Chase Senator. This deal infuriated the disappointed Whigs from the northern part of Ohio, and they would never forget or forgive Chase for what they said was his ruthless ambition. 12 years later, the Whig enmity towards the ex-Democrat Chase lingered, in part because the Ohio delegation to the 1860 Republican presidential convention in Chicago was divided, with some of his nominal Ohio supporters actually working against him behind the scenes. Chase's candidacy for the president was fatally undermined, eventually allowing former Whig Abraham Lincoln to capture the nomination. In Washington, as a Free Soiler, Chase, now back to his Senate career, Chase was marginalized in the Senate. The Democrats wouldn't caucus with him, and the Whigs wouldn't caucus with him. Still, he forged lasting bonds with a few other anti-slavery senators he met there, most notably Charles Sumner, the only other Free Soiler who, like Chase 2 years earlier, had been sent to the Senate by Massachusetts in a similar deal struck with Democrats there. Sumner considered Chase to be among his closest and most principled allies in the fight against the Southern slave power. Chase's past connections to the more radical elements in Congress would be a potent source of his clout during the Lincoln presidency. After the formation of the Republican Party, Chase was elected the governor of Ohio in 1855 on the Republican ticket, making him the first Republican governor in any state and the highest Republican office holder in the country at that time. After his failed bid for the Republican presidential nomination in 1860, the Ohio legislature returned Chase to the Senate, this time as a Republican, in 1861. When Lincoln appointed Chase Secretary of the Treasury, Chase vacated his Senate seat after serving all of 2 days. He was replaced by Clevelander and former Whig John Sherman, the future author of the Sherman Antitrust Act and brother of Union General William Tecumseh Sherman. Alone, as Treasury Secretary, alone among all the cabinet heads, Chase hired thousands of blacks and females as civil servants, and even placed an impressive number of black males in supervisory positions over white females. Also, alone among Lincoln's cabinet, Chase openly called for the abolition of slavery as early as 1862 and privately criticized the president for being so dilatory on the subject. He was clearly the person most lobbying for the Emancipation Proclamation, and Lincoln was when he finally decided he would do that, he went to Chase and said, "You're going to be very happy because I'm finally doing what you've been telling me to do." At the beginning of the war, when Union casualties overwhelmed hospitals in D.C., Secretary Chase, like others, opened his large house at 6th and E as a hospital ward. Among the gravely wounded soldiers who were nursed there was future Justice Oliver Wendell Holmes, Jr. As Treasury Secretary, Chase was charged with the Herculean task of financing the Civil War, preferably without raising taxes. His success at this endeavor made him invaluable to the Lincoln administration. Eventually, and reluctantly given his views of hard money, Chase acquiesced to the Republicans' plan to have paper money. But never shy about promoting himself politically, Chase saw to it that his picture appeared on the $1 bill, earning him a new nickname, Old Mr. Greenbacks. Chase's supreme competence in financing the war, along with his close ties to the radical Republicans in Congress, gave him political leverage with Lincoln, the former Whig, who came late in his career to the anti-slavery cause and who was distrusted by the radicals. Initially, Chase's working relationship with Lincoln was warm. Early in the war, for example, they sojourned together on a Treasury cutter off the coast of Virginia, where, with Secretary of War Edwin Stanton, they would plan a military invasion to secure the port of Norfolk. The three men, President Lincoln, Salmon Chase, and Edward Stanton, even personally went ashore to survey possible sites for landing troops. It's just kind of amazing to think about. That's what they were doing in a Treasury cutter off the coast of Virginia. Over time, however, Chase's often stiff and prickly personality, his incessant criticism of Lincoln's vacillation, coupled with his public political maneuvering for the Republican presidential nomination of 1864, put Chase at odds with the president. In June of that year, after Chase protested Lincoln's appointment of someone to the Treasury Department without his approval, Chase tendered his resignation, something he had done several times before as a means of influencing Lincoln's decision. Chase expected Lincoln to yield, as he had in the past, but this time he miscalculated. To Chase's surprise, Lincoln accepted Chase's resignation with considerable relief. By this time, Lincoln had already issued the Emancipation Proclamation, and the war was going better, and so he had greater clout with the radicals in Congress, and he had better political, the war was going his way, and so he felt he had the leverage to get rid of Chase. When a number of Chase supporters protested privately to Lincoln about his dismissal of Chase, knowing that his words would get back to him, Lincoln reassured them that, quote, "If I have the opportunity, I will make him Chief Justice of the United States," unquote. Now, perhaps in part because he heard about this, when Chase's bid for the 1864 Republican presidential nomination quickly collapsed, he nevertheless actively campaigned for Lincoln and the Republicans, traveling by train, boat, and horseback throughout Ohio, Kentucky, Pennsylvania, Michigan, Illinois, and Missouri. In October, when Chief Justice Roger Taney died, Lincoln was pressured on behalf of several other powerful candidates to be his replacement, leading him to delay his decision. Finally, after his re-election was secured, Lincoln nominated Chase, his political rival, to be the 6th Chief Justice of the United States. In a remarkable turn of events, the racist author of Dred Scott was succeeded as Chief Justice by Salmon Portland Chase, the Attorney General for fugitive slaves. On March 4th, 1864, Chief Justice of the United States Salmon P Chase administered the oath of office to his political rival, Abraham Lincoln, to inaugurate Lincoln's second term. The evening before, Chase was visited in his 6th Street home by the radical abolitionist orator and former slave Frederick Douglass. Douglass recalled helping Chase's dynamic daughter Kate, quote, now I'm quoting Douglass, in placing over her honored father's shoulders the new robe then being made in which he was to administer the oath to the re-elected president, unquote. Douglass recalled the early slavery days of their first meeting when Chase had, quote, welcomed him into his home and his table, when to do so was a strange thing, unquote. Douglass's faith in Chase was not to be disappointed. Chase readily agreed to the proposal by his friend Charles Sumner that Massachusetts attorney John Rock be admitted to the Supreme Court bar. The previous year, Rock, a black, had been denied admission by the Taney Court on the basis of race. Now, upon Sumner's motion, Rock was sworn in as the first black lawyer to be a member of the Supreme Court bar. Harper's Weekly observed that this event represented an extraordinary reversal of Dred Scott, and that it would be regarded by the future historian as a remarkable indication of the revolution which is going on in the sentiment of a great people. When Lincoln was murdered by John Wilkes Booth on April 14, 1865, Chief Justice Chase administered the oath of office to Vice President Andrew Johnson, a Democrat from Tennessee. 2 years later, when Johnson was impeached by the Republican House of Representatives for resisting its efforts to reconstruct the South, Chase, as Chief Justice of the United States, was called upon to preside over his trial in the Senate, as required by the Constitution. Now, there'd never been a trial of a president in the Senate before, and without any precedent to guide him, the physically imposing Chase swept into the Senate gallery, Senate chambers, with his flowing judicial robes, dramatically dominating the scene. Remember, he's very tall and he's very broad shoulders, and he's very charismatic in his appearance, and he sweeps into the Senate. He insisted that the proceedings against Johnson be administered as a judicial rather than a political tribunal. In part because of this, Johnson escaped conviction and removal from office by a single Senate vote. Chase, the way that Chase conducted Johnson's trial cost him political support amongst congressional Republicans. Old comrades of the anti-slavery crusade berated him for his scrupulously neutral conduct during the impeachment. His relative even-handedness at the trial helped kill his chances to be either the Republican Party's 1868 presidential candidate or the Democrats' 1868 presidential candidate. So let me talk a little bit now, turn a little bit now to the Chase Court, because we name courts after Chief Justices, so let me say a few words about the Chase Court. The Chase Court is not particularly memorable, but in the paper that is going to be published by the Case Western Law Review, on which this lecture is based, I do discuss several important and revealing opinions that he wrote concerning the citizenship of the freed slaves, in which he said that blacks were citizens of the United States before the 13th Amendment was enacted to establish that proposition, the legal status of the rebel states during Reconstruction, and the scope of the Commerce Clause, Necessary and Proper Clause, and tax powers, as well as the power of the federal government to issue legal tenders. I talk about all this in the paper, but I don't have time, unfortunately, to talk about it today. The last of these decisions, his decision that legal tender laws were unconstitutional, in contrast to the very same legal tender laws he had supported as Treasury Secretary, he later, as Chief Justice, said was unconstitutional, is beyond Congress's power. That last of his decisions would be reversed by the Supreme Court after President Grant appointed 2 new justices known to be sympathetic to paper money in what are now called the legal tender cases. In other words, it was really the first court packing scheme in which Grant appoints 2 justices that he knows are going to reverse the case that was decided 2 years earlier, and then that's what happens. And so legal paper can be made legal tender by Congress. Instead of talking about those cases, I'm going to conclude my discussion of his career by describing the last 2 cases he ever voted on, both of which found him in the minority. In response to Southern denials of the economic and personal liberties of the freed blacks, as well as of white Republicans, Republicans in the 39th Congress enacted the 14th Amendment. One key provision of this amendment was the Privileges or Immunities Clause, which reads, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States," language that was drafted by Ohio Republican Congressman John Bingham. In 1873, in the slaughterhouse cases, the Supreme Court gutted this clause by limiting it only to those rights which stem from the federal government, such as the protection of life, liberty, or property while on the high seas, or the right to access the American embassy, as though these were the privileges or immunities that Republicans in Congress amended the Constitution to protect. But from that day until this, because of the slaughterhouse cases, the Privileges or Immunities Clause plays no role whatsoever in constitutional adjudication. It's gone. It's just eliminated from the 14th Amendment. In his opinion for the majority, Justice Miller claimed that the basic economic liberties of property and contract, which were at issue in Slaughterhouse, were to be protected solely by state governments, a conclusion that was hotly contested by 3 dissenting opinions authored by Justices Bradley, Swain, and Field. Slaughterhouse is well known to be a 5-4 decision, and it is also widely regarded by constitutional scholars as wrongly decided. Yet, likely because he wrote no opinion in the case, and because the name of the Chief Justice was not included in those days in the Supreme Court reports, it is generally overlooked that the 4th dissenter in the Slaughterhouse case was Salmon P Chase. That same day, the Supreme Court also announced its decision in a case called Bradwell versus Illinois, a lawsuit in which Myra Bradwell contested the state's refusal to allow her to practice law because she was a female. And actually, she was a very distinguished member of the legal community in Chicago because she published the legal newspaper there and was married to a very prominent judge. And she was in her 40s when she applied for the bar, and she seemed to qualify under all the objective requirements of the bar, but the Supreme Court of Illinois said because she was a woman, she could not be a member of the bar. She then took this case to the Supreme Court. It was decided the same day as Slaughterhouse. For Justice Miller, who wrote the opinion in Slaughterhouse, Bradwell was an easy case. If the privileges or immunities of citizens of the United States did not include the economic liberty to pursue a lawful occupation, as the butchers in New Orleans had maintained, it didn't protect lawyers either. It protected neither butchers nor lawyers. Easy case. But because Justice Bradley had strongly asserted in the Slaughterhouse cases that the Privileges or Immunities Clause did protect the right to pursue a lawful occupation, he was obligated either to justify the discrimination against women as reasonable or invalidate the restriction. Well, he opted for the former. In a now notoriously misogynist concurring opinion, Justice Bradley explained why the legal incapacities of women, of married women, under laws of coverture, meant married women could not enter into contracts. If you can't enter a contract, how could you be a lawyer? Coupled with, quote, the paramount destiny and mission of women to fulfill the noble and benign offices of wife and mother, unquote, justified the legislative classification. In sum, whereas Miller found the 14th Amendment simply didn't apply, Bradley found that although it did apply, the classification by the state Supreme Court was a reasonable one, and therefore it was constitutional. And Bradley was joined in this opinion by Justices Swain and Field, who had also dissented in Slaughterhouse. Only the frail and aging Salmon P Chase, in the words of the Supreme Court reports, quote, dissented from the judgment of the court and from all the opinions. He didn't just dissent from the majority opinion or the ruling in the case, he also dissented from the concurring opinion of Justice Bradley. It's a single line in the report. At this point, Chase was too weak and ill from a series of strokes to write opinions in either case. 3 weeks after the decisions in Slaughterhouse and Bradwell were announced, a final stroke took his life. Given its beginning in the fight to emancipate blacks held in bondage, to its very ending in his final vote to uphold the equal civil rights of women, the long career of Salmon P Chase deserves to be remembered and remembered fondly. Now, I hope I've told you enough about the remarkable career of Salmon P Chase to lead you to ask the question, so why don't we know his story? Now, the most obvious answer to this question lies in the one thing that Chase is most known for today, if you know about anything, and that is his lifelong political ambition, in particular his ambition to be President of the United States, which has diminished his memory. In other words, it's not Chase's deeds that account for his neglect, but his alleged deficiencies of character. But this can't be a sufficient explanation for Chase's neglect by history. For one thing, ambition is rampant among persons in public life who achieve what Chase achieved. Even if we limit our focus to Chase's contemporary political rivals, Doris Kearns Goodwin's book, Team of Rivals, make it evident the enormous political ambitiousness of Chase's competitors, William Seward of New York, Edwin Baste of Missouri, and Illinois' Abraham Lincoln himself. But what emerges from Goodwin's fascinating treatment is that Chase was simply not as gifted as the others in concealing his ambitiousness. In an age when ambition was so frowned upon that presidential candidates were not even supposed to campaign on their own behalf. In the end, despite his many political accomplishments, try as he might, Chase was simply not a wonderful politician. Especially in contrast to Abraham Lincoln, Chase was not what we would today call a people person, which even then was extraordinarily important, both to achieve high office and to succeed in the offices one achieves. Remember as well that Chase was a former Democrat whose core political convictions put him at odds with the more numerous former Whigs who formed the Republican Party. So Chase was condemned to be distrusted and resented by both his Democratic enemies and by his Republican friends. Although he had helped found at least three political parties, the Liberty Party, the Free Soil Party, and the Republican Party, in the end, he was truly a man without a party in an age of violent, literally violent, partisanship. In a sense, Salmon Chase was simply his own man for better, but also for worse. Which brings me to another of Chase's character traits that comes through his various biographies. Chase, both consciously and unconsciously, aspired to be a man of great principle. That's what he aspired to be. And he largely achieved this aspiration. In very few instances can he be found betraying these principles for the purpose of attaining the offices he held or the one office that eluded his grasp. Instead, he always tried to win while championing his principles, something we might consider admirable rather than deficient. Chase was what we would today call a conviction politician. As George Templeton Strong eulogized after his death, Chase was, quote, an anti-slavery man long ago when anti-slavery opinions seemed an absolute bar to all hope of social or political advancement, unquote. And what this tells us is that however personally ambitious he was, and he was, ultimately Chase put his principles ahead of those powerful ambitions. And this must mitigate against the charge that Chase was only about ambition and nothing more. Indeed, it's ironic that to some extent Chase's very public proclamation of the principles, his principles might well have contributed to his negative reputation. How does one politically attack a conviction politician who justifies everything he does on the ground of such great noble principles as liberty and equal rights? Well, one way is to attack his character. Say he does what he does, not because of the principles he espouses, but because of his naked ambition. That way, we are free to disregard the principles along with the man who is advocating them. In short, you counter a conviction politician with an ad hominem argument that undermines his apparent commitment to principle, which is all the more effective if there's a basis in fact and his character that even his friends would acknowledge. Such ad hominem arguments should not be used to conceal the career of a man who contributed so importantly to the end of slavery. So with all this in mind, let me close my account of Salmon P. Chase with the assessment of him rendered by his greatest political rival, Abraham Lincoln. If anyone had a complaint about Chase's character and ambition, it was he. Yet, as was his wont, Lincoln adamantly refused to let his judgment of Chase's personality cloud his assessment of Chase's abilities and his principled commitment to the equal protection of civil rights. On the morning Lincoln intended to reveal his choice of Chase to replace Roger Taney as Chief Justice to the public, he was visited by Chase's supporter, a man named John Alley of Massachusetts. When Lincoln informed Alley of the news that he thought would make his visitor happy, Alley responded as follows: "Mr. President, this is an exhibition of magnanimity and patriotism that could hardly be expected of anyone. After what he has said against your administration, which has undoubtedly been reported to you, it was hardly to be expected that you would bestow the most important office within your gift on such a man." Of course, if this is what your friends are saying about you, it's clear you have a little bit of a problem. Lincoln's succinct response puts the issue of Chase's character in what I think is precisely the right light. Quote, "To have done otherwise," he said, "I should have been recreant to my own convictions of duty, to the Republican Party, and to the country. And," he said, "as to his talk about me, I don't mind that. Chase is on the whole a pretty good fellow and a very able man. His only trouble is he has the White House fever a little too bad. But I hope this may cure him and that he will be satisfied," unquote. So when you drive down the street and you see the name Chase illuminated every few blocks, think of all that man being honored by those signs accomplished, and how Lincoln characterized him. A pretty good fellow and a very able man. Oh, yes, and one of the persons most responsible for ending slavery in the United States. Were it not for Chase, the Republican Party might not have adopted the constitutional stance it did, and it was that stance that provoked the South to secede, which led to the Civil War, which led to slavery's demise. Upon his death, the New York Tribune eulogized, quote, "To Mr. Chase, more than any other one man, belongs the credit of making the anti-slavery feeling what it had never been before, a power in politics. It had been the sentiment of philanthropists. He made it the inspiration of a great political party." Or, as historian Eric Foner put it, Salmon P. Chase, quote, "lived to see his political approach to the slavery issue spread from a handful of abolitionists to become the rallying cry of a victorious political party," unquote. Each of us should envy that accomplishment, and all of us should remember it. Thank you.
We have time for one or two questions, if there are any. If you have a question, just please step up to one of the microphones. You don't have any questions?
Yeah, one, please.
Sure, please.
Wonderful presentation.
Thank you.
Thank you. Really valuable.
I'm going to tell my wife I got 2 ovations. That doesn't happen very often.
You described him as having a lot of difficulty in communicating with colleagues that, as I heard it, that both in particular in the Senate and where others wouldn't caucus with him and so forth.
No, that was just because he was a free soiler and he didn't belong to the Democratic Party, didn't belong to the Whig Party, so they froze him out because he was this bad anti-slavery guy.
All right, so you closed by saying he had such a profound impact in having the concept adopted. How do the two square, he as a person, and his skills?
Right. Well, he was first of all, he's a very religious guy. He was very self-righteous. He was a very righteous individual, and so he wasn't really warm and fuzzy. I could tell you a lot of bad stories about Chase in this regard. I mean, he would criticize his daughter's letters as being, not good enough or not bad enough, or he said, well, this is a good one, but this was a bad one. So he was very, very rigid, and he had another character trait that made him not such a good politician, and that is he was nearsighted, and he needed glasses, but he was vain, he didn't want to wear glasses. So as a result, he couldn't recognize people very well that he met, and so he doesn't always know who they were, and that also made him look diffident and aloof. So he had a number of these issues. But he was actually pretty effective. When he was in the Senate, he allied with Josiah Giddings and Charles Sumner to issue something called a Report of the Independent Democrats, which is what they called themselves, to oppose what was going on in Kansas at the time with respect to Kansas and eventually the Nebraska-Kansas Act. So he was actually, not effective because he couldn't be a member of any party structure. Where his effectiveness, I think, really pays off in terms of being an ultimate success was that early constitutional vision that he developed first as a litigator and then as a founder of this party, which formed the legal basis and of the platform of the Liberty Party, Free Soil Party, and Republican Party. And it was those parties, the Republican Party in particular, and that platform that plank in their platform that caused the South to secede and provoked the Civil War, and then which was eventually not originally about slavery, but was eventually made to be about slavery, in part because of the urgings of Chase and others. Judging by his effect, the effect of his life, the effect of his contribution, I think it was major. Any one of us in this room, I think, would envy being able to say that they'd been able to accomplish that the way he did. Now, he didn't do it alone. Obviously, many, many other people were important to this, but he was a moving force and as I say, acknowledged to be so at his death, eulogized to be so at his death.
Well, two things. First, you mentioned that he hired women and blacks after he managed, I think, at Treasury?
Yeah, when he was the Treasury Secretary,
Yes,
and he was the
and-
only cabinet secretary to do that.
I mean, it's amazing because, I mean, it's so easy to go with the flow, obviously, and then to be a man of principle. And clearly the moral principle is there, but when all of that other thought is against you, where do you think that came from? Like his parents, I mean, he moved from Vermont, you said, but I'm just saying, that's an amazing thing, and just the fact that, and I just wondered how many women and how many...
Apparently, it was quite a few. It was quite a lot, actually. Where does moral principles come from? I don't really think I know completely. I do think his religion had a very important role to play, and the religion played a very important role in most of the abolitionists. They were mostly quite religious and based what they were doing on the basis of the religion, and he did as well. He read scripture every morning, and I think that was an important part of it. But look, he was in Ohio. And Ohio was, as some of you may know, Ohio was a breeding ground of anti-slavery activities, partly because the influx of New Englanders into the Western Reserve in the North, and partly because, as I said, the outflow of expatriate Southerners who were anti-slavery, who were driven out of the South, who felt they had to leave the South, and basically Cincinnati is the first place you get to, out of Kentucky. And so you had, but of course there's a lot of pro-slavery attitudes in southern Ohio, and so now there's a real volatile mixture that's going on down there, whereas up north you have a lot of New Englanders coming in with their anti-slavery attitudes, like Chase himself. I mean, the other fellow who I actually was quite interested in, which drew me into this whole constitutional abolitionist movement, was a fellow named Lysander Spooner, who I've written about. He was a Massachusetts attorney. Also, weirdly coincidentally, went up for the bar after only studying 2 years instead of 3, and he was denied admission, and then he petitioned the Massachusetts legislature to change the rule, and they did, and so he got to be a lawyer. It was like this weird thing between the two of them. They both had this thing. But the other thing about Spooner, which tells you a little something about what was going on in those days, is after he practiced law for a short time and not all that successfully financially, he came to northern Ohio to settle and engage in land speculation, and he purchased all the land that eventually became Grand Rapids, Ohio, which is outside of Toledo. It was then he named it Gilead, a town, and it was a speculation in which he was hoping that a canal would actually be located close to there, but the canal was located elsewhere. He lost his speculation, and he went back to Massachusetts, where he then started working against slavery and wrote the book The Unconstitutionality of Slavery. So there you see a direct New England, Northern Ohio connection, which I think brings an awful lot of anti-slavery sentiment into the state of Ohio. And as a result, there's a lot of people that come out of Ohio that are leaders in this. And I mentioned in my talk John Bingham from Ohio, who was from the eastern part of Ohio near Pennsylvania, and he wrote the words of Section 1 of the 14th Amendment as a congressman from Ohio, not the Citizenship Clause, but he wrote the Privileged Immunities Clause, Due Process Clause, and the Equal Protection Clauses. He wrote every word of that, and it was in there because of his insistence. And he's also from Ohio. So there was an awful lot of Ohio anti-slavery activity which deserves to be remembered.
One quick follow-up?
Sure.
You gave that beautiful language where he was arguing to the judge, where you said, well, the trial court missed it and Matilda went away and was lost to history.
Yes.
There was no appeals, or there was nothing? I mean, that was the end of that? I mean,
that's the way it worked. I mean, no. I mean, what happened after that, the only appeal that happened is that Bernie was then prosecuted for having violated the Fugitive Slave Act for assisting Matilda. And so he retained Chase to defend him. And that case went to the Ohio Supreme Court, and Chase made constitutional arguments in defense of Bernie. And then when he went to the Ohio Supreme Court reversed his conviction on the ground that Bernie didn't know, and he claimed not to know, and there's every reason to believe he didn't know, that Matilda was actually a runaway. And so they vacated his conviction on that basis and refused to reach the constitutional arguments that Chase had made. But that went to the Ohio Supreme Court without any decision on the constitutional questions.
One quick last question.
Okay.
Is there any documentation as to what Chase felt about, if he either met John Brown, or what he felt about Brown's upheaval, or what he felt about the violence in Kansas that was occurring?
Yeah, I should know the answer. I mean, I know that Lysander Spooner did meet John Brown, by the way. John Brown traveled an awful lot around the Northeast raising money for his activities, so he was quite well known to abolitionists. I'd almost be a little surprised if Chase hadn't met him, but I don't know that he met him. And I do know that he was actively, when he was in the Senate, very much involved in opposing involved in the Kansas controversy as a senator from Ohio. But beyond that, I don't know of any John Brown, and I can guarantee you that if I had seen a John Brown connection and everything I'd read, it would have made it in here. I've got the Oliver Wendell Holmes Jr. thing where he was nursed in his home, so I'm looking for all little tidbits like that, and I didn't see any John Brown
Was there
connection.
an opinion as to the Harper's Ferry upheaval?
Not that I can recall. I mean, one of the things about Chase, which I have to admit that I haven't done because there's a limited amount of time in life, and I was involved in that little bit of litigation on the Obamacare thing, is that he has there's 5 volumes of his collected diaries and papers, and I just haven't gone through all of them. Most of what I know from the biographies that he's written and the speeches that he's given that I've read and the arguments that he made in court, which I've read. I really was more interested when I started this project in his legal arguments, and it was from there I got to the rest of the story about Chase. And I was very, very pleased when John asked me to give this lecture, because I've been waiting for an Ohio invitation. I figured, when would it be appropriate to write a whole lecture about Salmon P Chase? I knew it was coming sometime, and it was when I got an Ohio invitation, and you guys beat the University of Cincinnati to the punch, and that's what I'm doing.
We have a small token for Randy, and we'll have a reception under the rotunda just behind this wall. So if other questions for Randy, you can talk with them then. But thank you again all for coming.
And I have to tell you that I do have to leave in a reasonable short time, so I catch a plane to New York, where I'm speaking at Columbia tomorrow. So I will be at the reception, but only for a period of time.